we have discussed in previous two videos. We have discussed order 1 and 2. Now in this video we will discuss the provisions of order 3 and all the rules under it. Now order 3 relates to the recognized agents and pleaders. Who are the recognized agents and pleaders? Now order 3 rule 1 says appearances etc may be in person by recognized agent and or by pleader. Now any appearance, application or act in or to any court required or authorized by law to be made or done by a party in such court may, except where otherwise expressly provided by any law for the time being in force, be made or done by the party in person, that means the person himself, or by his recognized agent, or by a pleader appearing, applying, or acting as the case may be on this behalf. So whenever the question of appearance before the court comes by the parties to the suit, so in that case, except where otherwise expressly provided by any law for the time being in force, that means there is exception if somewhere in this code some specific provision has been made expressly provided that some or such person only be entitled to appear and such persons will not be entitled to appear in those particular matters, except in those cases the person himself, that is party in person or by his recognized agent or by a pleader appearing or applying or acting as the case may be on this behalf. So the party can appear or his recognized and authorized agent can appear or a pleader who is professionally pleading, that means the advocates are all appears under this order and the procedure and the rules mentioned in this order. Okay, so the by a pleader appearing, applying or acting as the case may be on this behalf. Now provided that any such appearance shall, if the court so directs, be made by the party in person. Now the party always have the option in general either to appear in person or to send his recognized and authorized agent, or can opt for the appointment of a pleader who as a profession pleads for another on behalf of another people. But if in any case the court directs to the party that he should personally appear, then the party must appear in person. Okay, now who are the recognized agent? Now under rule 1 of order 3 said the party in person or by his recognized agent. Now what is recognized agent? Recognized agent is dealt with under order 3 rule 2. Now the recognized agent of parties by whom such appearances, application and acts may be made or done are, who are the recognized agents? A person holding power of attorney authorizing them to make and do such appearances, applications or acts on behalf of such parties. So persons who are holding the power of attorney, that means the power of attorney holder of the party in the suit, and who in that power of attorney, who by that power of attorney who has been given power to appear before the honorable court in law or legal matters or making applications or acts on behalf of the parties. Okay, now b clause b says person carrying on trade or business for or in the name of parties not resident within the local limits of the jurisdiction of the court, within which limits the appearance, application or act is made or done in matters connected with such trade or business only, where no other agent is expressly authorized to make and do such appearances, application and acts. So now in the second clause the scenario is that one is that power of attorney holder, and the second one is that persons who may not be a power of attorney holder but carrying on trade or business for or in the name of the parties within the jurisdiction of the court. And in that case the original party, the concerned party, is not a resident within the jurisdiction of the court. That means he reside outside it may be out of Indian territory, it may be a foreign country's national, but in whose name the party here within the territory of India or within the jurisdiction of the court conducting the business, that person may appear made application or act on behalf of the person or the original party living in abroad. But there is a proviso or catch that if there is in matters connected with it such trade or business only, where no other agent is expressly authorized to make and do such appearances, application and acts. So if the person concerned or the person who is residing outside the jurisdiction of the court or the Indian territory, or who cannot appear in person, if he appoints for that specific matter any person for to just to do for the acts. Suppose someone appoints an advocate for his legal matters concerning the business. Then, in such case, the person appointed to look after the legal matters will be a recognized agent. Okay. Now, Rule 3 of Order 3 says service of process on recognized agent. Now, Subrule 1 says process served on the recognized agent of a party shall be as effectual as if the same had been served on the party in person unless the court otherwise directs. So, serving the process or the summons on the recognized agent of a party means that the party has been duly served unless the court otherwise directs. And Subrule 2 says the provision for the service of the process on a party to a suit shall apply to the service of process on his recognized agent. So, the provision of the service of process on a party to a suit shall apply to the service of the process on his recognized agent. Okay. Now, appointment of pleader. Now, here we just read that recognized agents are who are the power of attorney holder, the pleader, appearing, applying, or acting as the case may be. Okay, in Rule 1, the last line we have read that now the who how to appoint those pleaders. The advocates are appointed under this. I have already said that advocates are given power to plead your case under this order. Now, how to appoint an advocate or pleader? Now, appointment of pleader, Order 3 Rule 4 says, Subrule 1, no pleader shall act. I'm requesting please everyone keep your Bear Act with you so that you can follow the exact provision. It will be much more helpful. Okay, so Subrule 1 says no pleader shall act for any person in any court unless he has been appointed for the purpose by such person, by a document in writing signed by such person or by his recognized agent or by some other person duly authorized by or under a power of attorney to make such appointment. Okay, so that is the provision of giving the wakalatnama. Okay, in this provision, this is the exact provision where we give power to the pleaders to plead the case on our behalf. And sub rule 2 says every such appointment shall be filed in the court. So wakalatnama will also have to be filed in the court, and shall for the purpose of sub rule 1 be deemed to be in force until determined with the leave of the court by a writing signed by the client or the pleader as the case may be, and filed in court, or until the client or the pleader dies, or until all proceedings in the suit are ended so far as regards the client. So, once you give a wakalatnama or power to the advocate or the pleader, generally it will continue till the end of the suit. But if someone wants to retire, or if you want to change your pleader, or your pleader doesn't want to continue your case, then in such scenario an application have to made to the honorable court in writing signed by the client or the pleader as the case may be, and filed in court, or until the client or the pleader dies, or until the all the proceedings in the suit are ended as far as regards the client. Okay, now explanation. For the purpose of this sub rule, the following shall be deemed to be proceeding in the suit. Okay, A says an application for the review of decree or order in the suit. This is also an application and can also be made by the party or his agent, or I mean the recognized uh, pleader. Okay, now B, an application under section 144 that relates to the restitution, provision of restitution, and under 152 that relates to the provision of having being applied for the removal of the clerical and arithmetical errors of this within a judgment or decree. So, an application under section 144 and 152 of this code in relation to any decree or order made in the suit, this is also an what is deemed to be a proceeding in the suit. That means these are not separate proceeding, these are the proceeding connected with the suit, within the suit. Okay, now first one is application of review, second one is restitution and the clerical and arithmetical error correction. C says an appeal from any decree or order in the suit, and D, any application or act for the purpose of obtaining copies of documents or return of documents produced or filed in the suit, or for of obtaining refund of money paid into the court in connection with the suit. These are the four scenarios provided by the Order 3 rule, Rule 3, where Order 3 Rule 4 Sub Rule 3, okay. Order 3 Rule 4 Sub Rule, Order 3 Rule 2. First one is making application for review, and 144, 152, and the code, the decree or order made code in, okay. Now C, appeal for from any decree or order, and D says any application or act for the purpose of obtaining copies of documents or return of documents produced or filed in the suit, or of obtaining refund of money paid into the court or in connection with it. In these cases, the party have to specifically give power to the pleader in writing signed by the party, or his recognized agent or authorized agent, and the pleader, and that shall be filed in each and every case before the court, or with the application, or the in the proceeding, that shall also be filed, okay. Now rule 3 says, rule 4 sub rule 3 says, nothing in sub rule 2 shall be construed a as extending as between the pleader and his client the duration for which the pleader is engaged, okay. Now everything that has been said under sub rule 2, everything that has been said under sub rule 2 not in any way extends the pleader's time for which he has been engaged. If at the time of commencement of the proceeding the pleader have been given the, or the at the commencement of the proceeding, on the document through which the pleader has been appointed, the written document where the time is specified, time is mentioned, that for 1 year or 2 year or for specific stage of the proceeding you have been appointed, then that pleader will be appointed for that specific time limit only, and the moment the time expires the pleader will be relieved from the proceedings, okay. Now, B says, as authorizing service on the pleader of any notice or document issued by any court other than the court for which the pleader was engaged, except where such service was expressly agreed to by the client in the documents referred to in subsection 1. And it also not mean authorizing the service on the pleader of any notice, documents, or documents issued by any court other than the court for which the pleader was engaged, okay. Now this is a very practical aspect of the proceeding. Now you have two litigations, and two separate pleaders you have appointed for these two separate litigations. Now your suppose litigation A and litigation B. Now this provision simply says that any document or process or service of documents or notice, whatever it may be, of litigation B cannot be served on the pleader appointed on behalf of you for conducting the litigation A, okay. He will not automatically get the authority to receive all your documents the court under which he is practicing. He is only responsible to receive the documents or notices or services or processes which is connected with the proceeding in which he has been appointed as a pleader, okay. Now coming to this is 4 of what? 4 of rule 4. Rule 4 says the High Court may by general orders, please keep your barrack with you, please. I'm requesting that High Court may by general order direct that where the person by whom a pleader is appointed is unable to write his name, his mark upon the document appointing the pleader shall be attested by such person and in such manner as may be specified by the order. Where the person is unable to write his name, his mark, the thumb impression must be attested by two independent witnesses, okay. Now sub rule 5 of rule 4 says we are under order 3, okay. No pleader has been engaged, no pleader who has been engaged for the purpose of pleading only shall plead on behalf of any party unless he has filed in court a memorandum of appearance signed by himself and stating A. The name of the parties to the suit. B. The name of the party for whom he appears. And C. The name of the person by whom he is authorized to appear. Okay. So, no pleader who has been engaged for the purpose of the pleading only shall plead on behalf of any party unless he has filed in court a memorandum of appearance signed by himself and stating the name of the parties to the suit, the name of the party for whom he appears, and the name of the persons by whom he is authorized to appear, provided that nothing in this subrule shall apply to any pleader engaged to plead on behalf of any party by any other pleader who has been duly appointed to act in court on behalf of such party. Okay. So in case a pleader is engaged by another pleader, these specific provisions will not apply. That's how the junior advocates are pleading under the brief of the senior advocate, because within the framework and the practice of within the practice of the court, the junior advocate is the recognized agent of the senior advocate. Okay. Now, rule this is rule 5 of order 3. Rule 5 of order 3 says, service of process on pleader. Any process served on the pleader who has been duly appointed to act in court or for any party or left at the office of or ordinary residence of such pleader, and whether the same is for the personal appearance of the party or not, shall be presumed to be duly communicated and made known to the party whom the pleader represents, and unless the court otherwise direct, shall be as effectual for all purposes as if the same had been given to or served on the party in person. So when the above complications are not, the above mentioned complications or the above mentioned complication within the rules are not there, if a process is served on the pleader who has been duly appointed to act in a court for any party or left at the office of or the ordinary residence of the pleader, and where the same is for the personal appearance of the party or not, whether the same is for the personal appearance of the party or not, shall be presumed to be duly communicated and made known to the party whom the pleader represents, and unless the court otherwise directs, shall be as effectual for all purposes as if the same had been given to or served on the party in person. Okay. Now 6, agent to accept service. Order 3 rule 6 says agent to accept service. Agent to accept service. Subrule 1 says, beside the recognized agents described in Rule 2, besides the recognized agents described in Rule 2, any person residing within the jurisdiction of the court may be appointed an agent to accept service of process. So beside the recognized agent described in rule 2, any person residing within the jurisdiction of the court may be appointed as an agent to accept services of the process. That person may be anyone who is duly appointed for the purpose of this servicing and receiving the process of the court. 2 says, appointment to be in writing and to be filed in court. Such appointment may be special or general, or shall be made by instrument in writing signed by the principal, and such instrument, or if the appointment is general, a certified copy thereof shall be filed in the court. Now if any other person is appointed, now the instrument through which that person is appointed, whether it is a special purpose or in general purpose, the certified copy of that document must be filed within the court with the court. Okay. Our now sub rule 3 of rule 6 order 3 says that the court may at any stage of the suit order any party to the suit not having a recognized agent residing within the jurisdiction of the court, or a pleader who has been duly appointed to act in the court on his behalf, to appoint within a specified time an agent residing within the jurisdiction of the court to accept service of the process in this behalf. Okay. The court may at any stage of the suit order any party to the suit not having any recognized agent residing within the jurisdiction of the court, or not having a pleader who has been duly appointed to act in the court on this behalf. The court may direct a party to appoint within the specified time an agent residing within the jurisdiction of the court to accept service of the process in this behalf. Okay. So this is order 3, which deals with the recognized agents and pleaders. Who are the recognized agents and pleaders? How will they be appointed? And what is the provision regarding their retirement? Everything has been dealt in within the or within order 3. Now coming to order for institution of suits. Now in case of institution of suits, the order 4 says rule 1, suit to be commenced by plaint. So every suit shall be instituted by presenting a plaint to the court or such officer as it appoints in that behalf. Every suit shall be presented instituted by presenting a plaint to the court and such court or such officer as it appoints in this behalf. And rule 2 says, rule 2 says, every plaint shall comply with the rules contained in order 6 and 7 so far as they are applicable. So that is the provisions or the orders of plaint and written statement. Now in case of plaint, we know that always duplicate copies of the plaint must be filed. This is for the purpose of service of summons. So now commencement of the suit, at the commencement of the suit, when it commences, at the presentation of the plaint to the court or the proper officer. Okay. Now register of suit. Register of suit, rule 2 of order 4 says the court shall cause the particulars of every suit to be entered in a book to be kept for the purpose and called the register of civil suit. Such entries shall be numbered in every year according to the order in which the plaints are admitted. Okay. Suppose that is suit title suit number 85 of 2024. This is the titling and the numbering of the suit, which is maintained through a specific department or registry department of the court, and that department maintains a book for that specific purpose. Okay, this is order 4, that is institution of suits.